You are now entering a dangerous liberty zone where God-given natural rights are held sacred and exercised. This is your warning. Tyranny, fascism, and censorship will not be tolerated. Ideas will be exchanged freely. Rigorous debate and open discourse is encouraged. If you are weak and your beliefs are fragile, you should leave now. Prepare yourself. We are now live on the Dangerous Liberty Podcast. All right, we are live. Welcome to the Dangerous Liberty Podcast, where we know that the only thing more dangerous than liberty is the lack thereof. We got a great show for you tonight. I'm really excited about our special guest, which I will get to in just a moment. But we want to welcome everybody. We want to welcome John Coleman. Let's see, we got Jason Ross over there, Michael Hinn, and many others. And I see up there in the counter, if you haven't said hello yet, make sure you do. Again, we got a great show for you tonight. Summer, how was your week?
It was good. There's some exciting stuff going on.
Yeah.
Productive couple of weeks. So
Awesome. About time we did something productive.
I know,
appreciate that. Chris, how was your week?
Still dealing with stupid people with the government.
Awesome.
Every day.
Sean, how was your week back there?
Going good, thanks.
Good. All right, folks. A couple things I just want to get out of the way real quick. Make sure if you guys haven't done so already, you have subscribed to our newsletter on Substack, which the link for that is down in the comments or down in the description below. We are getting much more, thanks to Sean back there, we're going to get much more regular on sending that out every Monday. We just got a huge shipment of, well, go check out the latest newsletter. We got a huge shipment in of things that I can't talk about here on YouTube.
on the tubes.
But I think you're going to enjoy that. But again, what we're going to do with that newsletter, that's where we're going to put out all the upcoming information, upcoming events. We send out discounts, some exclusive deals. You're going to be the first to hear when we get, shipments of hard to get items in, or if we just happen to get some extra stuff in.
Speaking of which, we did just get in an exciting new shipment of the Night Force field spotting scopes.
Yeah, we got the brand new
to the shop.
The brand new configurable.
How many did you buy?
All of them.
Well, I mean, essentially.
As many as
How
we
many
could.
are you keeping?
At least one of those. We got to review it, and it'd actually be great for the long-range schools as well. Yep. And folks, the way that we're going to do that, I'm going to introduce our guests here in just a second, but the way that we're going to do this, as we do with most of the time that we have guests, I don't always announce it, but I want you to go ahead and put down your comments and your questions over in the comments section for sure as we go. That's fine, but we're going to address those directly at the end. So if you want to save them to the end, that's great. Or if you want to throw that down there, Sean will actually be going through the comments, and he kind of puts them off into a little...
He stars them, puts them in the favorites.
Puts them in a little favorites section of the really good questions.
Don't get your feelings hurt if you don't get favorited.
Yes. What I will tell you, what is that called? A super chat?
Super chat.
I'll tell you what, if you're just dying to get a question and you super chat it up,
Super chat helps.
we will prioritize you for sure. But without further ado, I do want to welcome our guest tonight. He's Randy Barnett. He's a constitutional lawyer, author, law professor, and Second Amendment originalist. So if we bring on Randy, welcome. I'm sure, matter of fact, I know I left a lot out in that description of you. Introduce yourself to everybody, let them know who you are, and tell us a little bit about Randy.
Well, I'm an old guy, so a bio is very long, and I always get embarrassed when people read the whole thing. So you did a better job. I'm a law professor at Georgetown University Law Center. I've been a law professor, as we discussed, for over 40 years at three major schools. But I've been at Georgetown for 18 years, where I'm very happy. And I'm a constitutional law professor these days. I have been for several decades. But before that, I was a contracts professor. And before I went a law professor, I was a criminal prosecutor in Chicago for the Cook County State's Attorney's Office, where I was a felony court prosecutor and tried murders, rapes, and armed robberies. That was back in the day. I don't think they actually try murders, rapes, or anything in Chicago.
That was when it was quiet.
That's when criminal prosecutors thought that their job was to prosecute crimes. I mean, it's we actually did think that was our job, and we were actually very good at it back then. So if OJ had happened in Cook County and my supervisors had tried that case, OJ would have gone down. It was the incompetent LA DAs that were responsible for that travesty. So we OJ. we had a good shop there back in that day. Now, Kim Fox, the current Cook County
Right.
State's Attorney, not so much, but happily I'm not there anymore. So right now I'm broadcasting from the free state of Florida on Siesta Key in Sarasota, which is where I spend most of the year.
You lucky dog.
Sounds terrible.
I know,
Sounds
right?
terrible there.
I'm a little
Yep.
jealous.
One thing I do want to talk about, and I had a little bit of insight to this, is you actually have a brand new book out. I've already been reading it. You sent me a PDF. I went through and grabbed some excerpts that I'm going to share with everybody. But we have the pre-order link for that. That is going to be released July 2nd, folks. So go check his book out. It's A Life for Liberty. We're going to throw it up there on the screen. But the link for that is down in the description below. So make sure or you just go to Amazon and you can just search A Life for Liberty. Pre-order that coming out July 2nd. I think it'll be well worth your time. And again, we'll hit a couple of excerpts, but I'm telling you right now, it's definitely a book worth reading for sure. The other thing, as I was reading through your book, we've already talked about one of the things that I found very interesting about you was, one of the first things that you said to me when we were talking on the phone for the first time was, you're an originalist. And that always wasn't the case. And I was reading through a couple of excerpts on your book. And if you will, Sean, pull up page 427.
Well, may I interrupt?
Yeah.
Can you explain what you mean by the term originalist?
Sure.
Ooh.
It's actually pretty easy to summarize. It's the belief that the meaning of the Constitution should remain the same until it's properly changed by amendment.
Okay.
So let me say that again. The meaning of the Constitution should remain the same until it's properly changed by amendment. But Gary, if you don't mind, I'd like to just deviate from just one
Sure,
second
absolutely.
from this, because I want to thank you for your service to the country and thank all the instructors that work with you for your services to the country. I deeply appreciate it. I was invited. I was very honored to invited to give the Saul Feinstein lecture at West Point Military Academy last fall, which is the first time I got to visit West Point. And it was in the course of preparing for that lecture that I kind of actually it was while I was actually on base on campus, and I saw all the Beat Navy signs that were all over the
Right.
the campus. And all of a sudden I remembered, of course, there's this intersectional rivalry. And I had never really thought of the Barnetts as one family or another, but it turns out I realized the Barnett is an Army family. The Barnetts are. My great-grandfather, and I do discuss this in my biography, A Life for Liberty. My great-grandfather, Harris Barnett, at the age of 19, enlisted in the U.S. Army in Chicago. He was a Jewish immigrant from Russia, and he enlisted as soon as the news of the Little Bighorn and Custer's Last Stand had reached Chicago. And so within a week of Custer's Last Stand, my grandfather joined the U.S. Army, and he was discharged honorably in the Montana Territory after having fought in the Indian Wars. His son, my grandfather, Hiram Barnett, was an ambulance driver in Europe during World War I for the U.S. Army. And my father, Ronald Evan Barnett, and my middle name is Evan after him, he was in the U.S. Army Air Corps in World War II. Happily for us, he didn't actually make it into action. His class, he was in flight school when the war was nearing an end, and the Army washed out his class, so he never could get his flight credits as a pilot. But his brother, my uncle, was injured by a grenade in Europe, right where near Bastogne, just before the Battle of the Bulge. So luckily, it probably saved his life that he got this injury and had to be, medevaced out of Europe and got him out of the way of the Bulge. So we're an Army family, and I have to say that I dropped the ball, and during Vietnam got a very good draft number, 233. At the time, I said it's the only lottery I need to win. And as a result, I did not serve, although, there's part of me that does regret that. But it makes me doubly appreciative of those who have. And that's why, before we talk a lot about me or even about the Constitution, I really did want to, pay my respects and express my appreciation to you and all the folks that are associated with you, Gary.
Well,
Thank you.
We appreciate that very much. And
He's not wrong.
And the other part of that too is, we always talk about veterans, and they deserve recognition for sure. But the other thing that I always am trying to convey to my wife is how appreciative I am of the spouses out there, the kids that have to go through that, especially the last 20 years through so many deployments, through, they're veterans as well as far as I'm concerned. And
Absolutely.
we really do appreciate that, Randy.
And
Thank you.
Just to let you know, Markman77 over on Rumble. So thanks to Summer, who supported Gary as a hooah Army wife.
Hooah, Army wife. All right. Green Berets don't say hooah. All right.
I wasn't there.
Yeah. So, no, I really do appreciate that, Randy. And yeah, if you will, bring up page 427 for us. I want to talk about kind of your evolution from wherever you were, and you talk a little bit about kind of where your philosophical, your law philosophy was coming from. But right here it says, my first step toward becoming a con law or constitution law guy had been in the Federalist Society Symposium at Stanford in 1986 that led me to become an expert on the Ninth Amendment. The next step was meeting Don Cates, a gun rights activist lawyer who I had briefly been in the faculty of St. Louis University. Going down a little bit, in 1983, Don authored a piece in the Michigan Law Review called Handgun Prohibition and the Original Meaning of the Second Amendment, which was the first piece in the modern era that argued for an individual right, the very right that would be the subject of the High Court's Heller decision in 2008. Don's article inspired Sanford Levinson's 1989 Yale Law Journal article titled The Embarrassing Second Amendment. On 428, skipping down a little bit, eventually Don pitched to me the idea to collaborate on an article which became our 1997 article, Under Fire, The New Consensus on the Second Amendment. Published in the Emory Law Journal, it began until the early 1980s, the Second Amendment had received little interest or attention from legal scholars and went on to explore the original meaning of the second. On 429, it says, I still didn't consider myself an originalist. To the contrary, I was under the impression that originalism as a theory of the Constitution had been irrevocably debunked by Paul Brest, former dean of Stanford Law School, in his 1980 article, The Misconceived Quest for the Original Understanding, published as it happened by the Boston University Law Review. 4 years later, H. Jefferson Powell of Duke nailed the coffin shut, or so I thought, with the original understanding of original intent, published in Harvard Law Review. I would have described myself as Dworkinian. We'll leave that part out, but he sometimes called it the moral reading. This is interpreted in the Constitution to make it the best it can be. For me, this meant the most libertarian it could be. I remained steadfastly non-originalist, or so I thought, concurring with the established take by most legal scholars that trying to interpret the intent of the framers was essentially as impractical as guessing what was written under Robert Bork's infamous ink blot, channeling the framers, as I called it disparagingly in one article. So, you didn't consider yourself an originalist. I would kind of like to know the thought of, you can kind of expand on that. Like why didn't you? And why was the prevailing legal theories that there wasn't this original intent to begin with?
Well, part of the problem is looking for original intent itself, and that is the argument made against it, or what we always was called framers' intent, the intentions of the framers. And by that we mean the intentions of the people who wrote the document. What did they intend? And part of the problem with trying to do that was that it was a large body of individuals. They all had different intentions. They all had different motives. They had different objectives, and trying to come up with a collective intent of a body of people who have different subjective intents seemed to be a fool's errand. And that's one of the criticisms of originalism that was made by Paul Brest, which you mentioned in that excerpt. And the one that was made by Jeff Powell, the other article that's mentioned in the excerpt that you read, was arguing that even the founders didn't think. There is evidence, he presented evidence, even the founders didn't think you should rely on their intentions. And so therefore, that was another reason why originalism was kind of a non-starter, which it seemed to me made sense. I mean, I read those pieces. I was a contracts professor at the time, so there wasn't a huge stake in it for me. But as was already narrated in the pieces that you read, I started off by researching the Ninth Amendment. Let me remind everybody what the Ninth Amendment says, which it says that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So just because we put some rights in here doesn't mean that's the only rights we have. In your introduction to the show, you mentioned natural rights, and that's what they meant by rights retained by the people. The original meaning of rights retained by the people were natural rights.
Right.
So I learned a lot about the original meaning of that. Then I learned a lot about the original meaning of the Second Amendment. And that set up in my mind something that psychologists call cognitive dissonance. So what cognitive dissonance is when you are believing one thing, but then you're doing something that's inconsistent with what you believe. It's a psychological state that's uncomfortable for human beings to have. And what typically happens is you either adjust your beliefs to conform to what you're doing, or you adjust what you're doing to conform to your beliefs. And in my case, it meant that I was really quite susceptible to a good argument for originalism, since I already had become an expert on the original meaning of the Ninth Amendment, and I had already become an expert on the original meaning of the Second Amendment. And yet I myself said I'm not an originalist. That doesn't really make sense, does it?
Right.
And then I came across an argument made by a famous, in libertarian circles, a very famous radical libertarian named Lysander Spooner. Some of the people in your feed are going to recognize that name. Most of them will not recognize that name. He was a radical libertarian in the 19th century that I had read about when I was in college. And it actually goes to one of the questions that is in the chat about whether the Constitution is a contract or not. And what Spooner argued was it couldn't possibly be a contract. No one really agreed to it. We'll put that to one side. But I found out, and the book tells the story about how I discovered that Spooner wrote what turned out to be a book in 1845 arguing that slavery was unconstitutional under the original Constitution. Now, I thought to myself, how could that possibly be? When I saw the site, how could that possibly be in 1845, 20 years before the 13th Amendment abolished slavery? How could anybody argue that? So I asked the library to get me that work. It turned out to be a book. I read the book. And in it, Spooner uses a different form of originalism than was being debated at the time. And what Spooner was focusing on was not the original intentions of the framers. And in fact, he had to attack radical anti-slavery people and abolitionists who were making the argument that the original Constitution was illegitimate because it was a covenant with death and an agreement with hell. That's what the anti-slavery the radical abolitionists said, because the founders intended to protect slavery. And what Spooner said is, it doesn't matter what they intended. What matters is what they wrote. It doesn't matter what was in their heads. It doesn't matter what their objectives necessarily were. What matters was the original meaning of the words they used in the text of the Constitution. Bingo, I thought. The light went on. I said, now that's a theory of originalism I've never heard before. And it's one that I think I could do something with as a constitutional scholar and theorist. Theory is kind of what I do. And that's what happened. I took that theory and I ran with it. And it ultimately culminated in my book, Restoring the Lost Constitution, which was published in 2004, in which I defended what I called the new originalism, which was going to be different than framers' intent originalism. We were going to be looking for the original public meaning of the text as it was understood when it was enacted. And originalism, as I already defined it, is that the original public meaning of the text should remain the same until it's properly changed by an amendment. So that's how I went through that transformation. Now, unbeknownst to me, and it was kind of happily for me, Justice Antonin Scalia was then on the Court of Appeals in the DC Circuit. And I knew him. I'd spent a year at University of Chicago when he was a professor there, and I even sat in on his contracts class one time. He taught contracts. And so I knew who he was. I knew him. I wasn't close to him at that time. But unbeknownst to me, he was speaking to the Republican to the lawyers in the Justice Department who were working for Ed Meese, who was Ronald Reagan's second Attorney General. And he was giving private talks to them, and he was urging them to put aside this interest in framers' intent and instead look at the original meaning of the text. So he was actually advocating for that Spooner approach without, of course, he didn't get it from Spooner, only I got it from Spooner. And so he was telling those lawyers they should be looking at original meaning. And so when my book came out arguing for original meaning, it sort of had a receptive audience. And frankly, it changed the meaning of originalism as to how it's done. If you actually looked at the confirmation testimony of any of the recent justices, and the person that spent the most time on this was Justice Kavanaugh during his testimony. He insisted that it was the original public meaning of the text that binds us, not the original framers' intent. And so that's my contribution. It wasn't my contribution alone. As I said, Justice Scalia was already arguing for that, unbeknownst to me. But that's one of the things that sort of changed the face of originalism. And it's one of the reasons why originalism went from a theory that almost everybody thought had been refuted to a theory that today I would say is sort of the dominant theory, such that when Ketanji Brown Jackson was nominated to the Supreme Court and she was asked at her confirmation hearings what approach she would take, she said, I'm bound by the original meaning of the text. That's what she said. Now, that would not have happened 20, 25 years ago. Now, I'm not claiming that she actually is going to be bound by the original meaning of the text. I'm just saying that by this time, the norm had changed so much that the path of least resistance during her confirmation hearing, as coached by the Democratic White House, was to say she was bound by the original meaning of the text. That would not, when I was a law student, that was not an available alternative.
Wow. So, I mean, we see an entire legal paradigm shift in what, 20, 30 years.
Exactly.
That's pretty interesting. And, even going back to the excerpts that I read, what I find is amazing is that, essentially, the gentleman you talked about, Don
Case.
Don Case, he was this one guy that had this impact on you that completely changed the trajectory of your life. And I think that's really important. That's one of the things that really stood out to me because, as we have these interactions with people and, even do things on YouTube or whatever else, I think we really do underestimate the impacts that we can have on people. And not only there was that one interaction with him that changed the trajectory of your life, but imagine the amount of countless interactions that you've now had with students, with other folks that has had this ripple effect that is just, it's an exponential effect from that one interaction with that gentleman, Don. And,
let me tell you a little bit about Don Cates. Don Cates was a man of the left. He was a civil rights activist who was a freedom rider with African Americans in the South during the civil rights struggle leading up to the Civil Rights Acts being passed. And of course, because they were in the South, they were in great jeopardy. And so he learned he became a gun aficionado, and he packed a gun. And now not everybody who worked in the civil rights movement in the South did pack a gun, but Don did. And he became a individual gun rights activist from the left as a civil libertarian lawyer. He worked for William Kunstler, who was one of the most Marxist defense lawyers that we've ever produced. And yet Don changed Don is who broke the water here with this broke new ground with his Michigan Law Review article. He's really the guy that gave us Heller. And one last thing I will say is where I first met Don, that I talk about in the book, was he got a little bit of money from the NRA. I know the NRA gets a bad deal these days, and deservedly so. But he got a little bit of money from the NRA, and with that little bit of money, he had these conferences that he'd invite law professors to attend. And one of the spiffs of being at one of these conferences is you would go shooting. And so this one was held in Orlando, the one I went to, and we went to the sheriff's training facility there, and all the local gun guys came out with all the different guns, and I picked a .44 Magnum because I'm a big Clint Eastwood, Dirty Harry fan.
That's what I'm talking about.
So I picked the .44 Magnum. I didn't get to fire the full auto guns, which I missed out on, but I did the .44 Magnum. But so his only obligation, the only thing he asked you in return for paying your way to come to these conferences where you talk about the Second Amendment, is you had to commit to writing something about the Second Amendment, even if you were against the Second Amendment. You didn't have to commit to writing something for. But so I wrote some op-ed or something about it, and so it was that little bit of seed money that got me down there to meet Don, and then eventually he pitched the article, doing this article with me, and then I did it, and I became a Second Amendment scholar as a result.
That's phenomenal.
Randy, I'm sorry to close the circle.
I just fell in love with you more when you said you're a Clint aficionado.
I actually, I guess,
Gary,
I
Gary
actually,
probably doesn't know as much as I do about Clint.
Oh
but
my
that's
God.
one
I,
thing
I
do
actually
know.
have the
Actually,
privilege.
have you been to the movies and seen one of the Dirty Harrys?
No, I'm not
you
that
haven't.
old. I'm not that old.
I know. So don't
No,
even sit
I'm
there
not
and play
going
that
Dirty
game.
Harry. I'm doing Josie Wales. That is my #1 Clint movie. Is Josie Wales. That's my.
But one of the chapters that got cut out of the book that's not in the memoir is a chapter of a Hollywood before the Oscars party I got to attend. And Clint Eastwood was there, and he's the only guy I went up there to talk. I saw all these stars. I mean, I countless stars that were at this party because it was sponsored by Tom Cruise and Will Smith and a bunch of other people. But Clint Eastwood's the only guy I wanted to go talk to. So I went up to him and I started talking to him a little bit about his politics. I understood he was a libertarian. And so I did get to make a personal connection with Clint Eastwood one time.
Man.
That's really cool.
I saw him in person from afar down on the street in Savannah filming with his daughter, a movie down there.
That's awesome.
Midnight in the Garden of Good and Evil, when he was directing that movie with his daughter.
He's a fine director.
I had lunch with him last week, so
Sorry.
I just
Clint's the
want to
Clint's
all
the
you
man.
guys.
Sorry you feel left out.
Clint's the man. A lot of people don't know about Clint. A lot of people do, and Clint's the man.
He is. No, and I'll tell you, he is a rarity among Hollywood. Even going back in the day.
Uh-oh.
But with that being said, bringing this back on track a little bit, going back to the originalist intent when it comes to the Second Amendment. For those of you out there, hopefully you know this pretty well, but the Second Amendment says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So, there's there's a couple commas in there that get, I believe, misconstrued. But, Randy, what is your opinion, especially when it comes to, the well-regulated militia part? Because that's the one that gets used on the anti-gun side very often. What is, in your opinion, the original intent behind the Second Amendment?
Words?
The contextual.
Contextual.
The original public meaning
Yes.
of those words. Well, it's actually that the Second Amendment was kind of a mashup of a couple of different provisions that James Madison had proposed to Congress. And I guess one of the things we need to do right now is give credit to James Madison for what we call the Bill of Rights. He's called the father of the Constitution. And in fact, there are other people at Philadelphia that had at least as big an impact as Madison had. So that might be somewhat of an unjust title, but I don't think there's any doubt that he is the father of the Bill of Rights, because once he got in as a congressman in the first Congress, the Federalists weren't all that interested in having a Bill of Rights, and he kept getting up and pestering them until they finally formed a committee and they said he could be on it. And he drafted a bunch of proposed amendments, and he had one reaffirming the importance of the militia, and he had another one talking about the right of the people to keep and bear arms. And that ended up getting mashed together. They were trying to make these amendments shorter and more concise, and it ended up getting mashed together. And essentially, and I basically think that Justice Scalia was completely right about this in his opinion in Heller. The militia clause is basically an explanation of one of the purposes for an individual right to keep and bear arms. So the militia, having the preservation of a citizen militia, is an end, and the protection and the legally enforceable right to keep and bear arms is the means to that end. Because you could, how are you going to preserve a well-regulated civil, we'll put well-regulated aside for a minute. How are you going to preserve the existence of a citizen militia? Well, you could have a commandment to Congress that says, thou shalt not abolish the militia. But these commandments are easily disregarded, and many of the commandments of the Constitution have been long disregarded. And so that's part of the thing that turned me off of the Constitution when I was a law student, finding out how much of the Constitution was ignored. I call that the lost Constitution, all the provisions that are ignored. So, but there's another way of protecting the existence of a citizen militia, and that is to ensure that you don't disarm the people. And if you don't disarm the people, that's one way of making sure that you have a citizen's militia, and which happily in our country is the case, that the people have not been disarmed and the militia still exists. It even exists under federal law. The militia under federal law consists of two different parts: the organized militia, which is the National Guard, and then it's the unorganized militia, officially recognized in the United States statute. The unorganized militia is all able-bodied white males between the ages of 18 and 45. Well, I actually think that's what the statute says, but I do think the militia now is is bigger than that. But nevertheless, the existence of an unorganized militia is recognized and has long been recognized in U.S. law. And that's how you keep the militia, is by making sure that the people are not disarmed. Now, let's talk about it well-regulated. What is well-regulated? It's the easiest way to understand that is it means well-trained.
Well-trained, yeah.
Well-drilled.
Yep.
The militia, you were expected to do your militia duties, which means you had to come and assemble. You had to make sure that you had an operable firearm. The government didn't provide you with one. You had to have your own. Eventually, they standardized what weapons they expected you to have. And then you had to show up for drill because a militia needs training. And I think actually our militia needs training. If I can say one thing about that, in the wake of 9/11, shocked as I was like everybody else, within about, I think about a week, I had my first public op-ed on that. It was called Saved by the Militia, in which I credited the people on the flight in Pennsylvania for having organized and acted as members of the militia to protect Washington, D.C., where that plane was headed, and force that plane down before it could hit its target. And then at the end of that piece, I closed by saying it would be better if the militia, which still exists, were better trained. Can you imagine if the federal government actually gave tactical training and weapons training to all members of the general militia? That would be terrific. It might crimp your business a little bit at Paramount Tactical.
We get that government contract money. That's all right.
Yeah, there you go. There you go. I'm sure it would have to be contracted out.
Well, it should at least be, tax deductible, which, I don't know if you know this, Randy, but, West Virginia did just pass a law to where all ammunition and firearm sales are tax deductible here in West Virginia.
Not tax
No, they're
deductible,
tax-free.
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 You were correct. I stand corrected by the wife.
That sounds like wild and wonderful to me.
Yep.
You damn right.
We need to get Florida on that bandwagon.
Right.
So, yeah, again, I always see that argument, basically, the argument in summary from the left or from the anti-gun folks is that this was a right that was only intended for a militia. And then, of course, out of the same side of their mouth.
Not a select militia.
Correct.
When they say militia, they mean what they're thinking about is the select militia, and the select militia were those members of the general militia who were called into active service.
100%.
Now, the Constitution, elsewhere in the Constitution, outside the Second Amendment, it gives Congress the power to organize and to call forth the militia. Anybody they call forth becomes part of the select militia, but it presupposes the existence of a general militia that you then choose people from to serve in the select militia. So when the term militia in the Second Amendment does not refer to a select militia, it refers to the general militia from which a select militia is selected.
Well, and regardless of that, the last part of that's really important. It says, because the right of the people to keep and bear arms shall not be infringed, which is secondary to that entire first portion of that sentence. So I don't even. I think they kind of have to do some mental yoga to even get to that point to begin with. But I did want to hear your thoughts on that. And
let me add one more thing. The kind of theory that what I call the militia-centric theory, which I have a separate article about. I'll send you this article about the militia-centric conception of the Second Amendment. And that theory is relatively recent vintage. You can find individual state court judges in the 1830s saying something like that. And when they do, they sometimes even admit that what their view is a minority view. This view did not exist at the founding. I'm going to say something shocking, and I've done this in debates with people who are on the other side, and so I've survived asking this challenge. But the people who put forward the militia-centric theory of the Second Amendment have yet to produce a single example of anyone at the founding who held that view of the Second Amendment. Not one. They don't have one person who's ever said at the time of the founding that the right to keep and bear arms was limited to some kind of organized militia service. Now you have to say, well, what are all about the books they've written and all about the articles they've written? What do they say in those articles? All the evidence they have is all about how the founders loved the militia.
Right.
they've got a lot of quotes about how great the militia is, but they don't have a single quote from anybody who thought that the right to keep and bear arms, that, as you rightfully pointed out, is a right that belongs to the people. Just like the Fourth and Fifth Amendments are rights that belong to the people as individuals. They don't have a single person who said otherwise. In the 1830s, you start seeing some people talking like that, but it doesn't really catch on until the 1960s, until the great crime wave that hit this country. And then you had the anti-gun movement developed. And at that point, a lot of circuit courts, a lot of federal circuit courts adopted that as their theory of the Second Amendment to turn away challenges to now new gun controls that had never been proposed in this country before. This is all new. This is all a 1960s development. And it then, as you said in the early, in the quote that you took from my book, in the 1980s and 90s, individual rights scholars like myself began pushing back against that 1960s understanding. But we're not pushing back against an understanding that goes all the way back to the founding. Far from it.
Yeah, no, that's remarkable. The when it comes to the founders, we talked a little bit about of their view of the Second Amendment, and just like you stated, not only I've never obviously looked for a founder quote or any writings or the Federalist Papers where they're talking about how the Second Amendment only applies to some sort of militia. I've never looked for that, but I will say I have looked for the opposite side of that, where they're explicitly talking about the individual right to bear arms, and that is talked about by many founders. It's talked about specifically in the Federalist Papers and things like that. And not only that, you see that in practice during that period. There was no, and you correct me if I'm wrong, there's another question I have for you. When was the first time, or was there any sort of gun control at all that, as we know it today, that was in place in this country during the founding of this nation?
The earliest gun controls that there is some regulation, for example, of gunpowder and how gunpowder should be stored, because gunpowder in an urban area was obviously a dangerous thing. And so, especially in these cities that are completely made out of wood, essentially wood construction. And so there was some regulation of gunpowder because gunpowder was dangerous. Sure. Inherently dangerous. And so that was one of the liberties that got regulated. The first real gun control laws that we've had in this country were laws that were aimed at both African slaves and free blacks as well, that restrict, especially in the South. So the first gun control laws we saw in this country were in the South, and they were aimed at slaves, at the enslaved people, and there were free blacks in the South as well, and they were their ability to own firearms was also restricted. And so that's the first kind of gun controls that we saw.
Democrats have been consistent over time.
In many ways.
So
they have supported gun control always. So there's that. And, just going back on that real quick, I thought it funny when you were talking about how Don Cates was a leftist. And that was very different from a Democrat at the time. Basically, what he was doing was carrying a gun to protect himself from Democrats during those times. And I think that is a interesting dichotomy when we think back at time of how these political ideologies have sort of merged and converged and diverged over time. But, it was the same Democrats back in the South that were wanting gun control for many different reasons. They were absolutely pro Jim Crow. Those were all Democrat laws that were put into place, and ultimately it was Republicans fighting against those things. But anyways,
well, actually, can I? No, that's not a digression. I need to pick up on that because I actually did. When we scheduled this, there was one important point that I really wanted to make to you and your audience, and that is that it's very important to remember that the Second Amendment, whatever it may mean, and I've already said what I think it means, only applied to the federal government. It was only a restriction on the federal government's power.
Yep.
It was not applicable to states. As I said, the earliest gun control laws that were done by Southern states were aimed at enslaved blacks and free blacks, and they were within their constitutional power, their federal constitutional powers to do that. And of course, They did a lot worse than that too. They maintained slavery. So how can we assert our individual right to keep and bear arms against states today? Why can you make a Second Amendment challenge, so-called, to high capacity or standard capacity magazines or whatever?
Doesn't the Supremacy Clause cover that?
No, it is the 14th Amendment. So the reason why I was remembered to say this is you just credited the Republicans for this in response to this Southern oppressive behavior, but it was the Republicans who gave us the 14th Amendment. First of all, they gave us the 13th Amendment, which abolished slavery, and secondly, they gave us the 14th Amendment that was designed to protect what the amendment calls the privileges or immunities of citizens of the United States. And among those privileges or immunities that they were very, very conscious to protect, because they expressly named it in the Freedmen's Bureau Act, the constitutional right to bear arms, they called it in the Freedmen's Bureau Act, was the constitutional right to bear arms. That was being denied in the South. It was being denied to Union veterans, African-American Union veterans who went home with their Army rifles. Another example of how there wasn't a big difference between civilian-owned weapons and military weapons. They were basically the same in this country until extremely recently. And so they took their weapons home, and then they were being disarmed by Southern state governments. And one of the reasons why the 14th Amendment was enacted was to give people an opportunity to challenge those laws in court, in federal court, as well as to give Congress the opportunity to protect those rights from the Southern states with a new power it was given under the 14th Amendment to enforce the rights that were identified there. So all of the rights that we have against the state governments to protect all our rights to guns against state governments comes from the 14th Amendment. And here's the dirty little secret. The people that want to argue for the militia-centric version of the Second Amendment have almost nothing to say about the evidence surrounding the original meaning of the 14th Amendment, because the people who were the bad actors that amendment was enacted to protect African Americans against were local militias. White militias were the bad guys in the South. And they were the ones that were systematically disarming African Americans and many of them were veterans. And that they were the bad guys, which is another reason we know that the right to keep and bear arms that's protected by the 14th Amendment was an individual right, that it belongs to all of us as American citizens.
No, that is interesting. I wasn't aware of that. And as a matter of fact,
Chris, you look mind blown.
while we're sitting here, because I wasn't super familiar with the 14th Amendment, but I'm just going to go ahead and read this for everybody out there.
I'm just listening.
It says the 14th Amendment: all persons born or naturalized in the United States, subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction equal protections of the law. So I think that that's a good amendment that more of us should be more familiar with.
I want everybody to pre-order my memoir. I want everybody to pre-order my memoir, so I don't want to distract from that. But if you're interested in the 14th Amendment, this was my most recent book before the memoir, and that is The Original Meaning of the 14th Amendment, which I co-authored with Evan Bernick, and it tells the whole story of the rise of the Republican Party, the rise of the Republicans' conception of citizenship and civil rights that they enshrined into the 14th Amendment, which includes the right to keep and bear arms.
All right, and since we're on it real quick, I want to hit that number one to make sure we're supporting Randy. At the end of this, folks, what we're going to do is we're going to do a couple of drawings, and we're going to give away pre-orders, 2 pre-orders of his books and 2 orders of what was that book that you wrote, Randy? What was the name of it?
The Original Meaning
of the 14th
Amendment.
All right, so we are going to give 2 and 2 away of those.
Can I get on that drawing?
You can get on that drawing.
Nice.
Matter of fact, I'm just going to buy you one, Chris.
I appreciate it.
I got you covered, buddy.
I need something to do at work.
You need to read. We'll give it to Jason. You know why we need to give it to Jason.
Fair warning. The memoir is going to be a lot easier read. I just have to warn everybody. So the memoir.
So Jason, that'll be the one for Jason.
The memoir is a fun read, this book can be a little bit heavy, but anyway, it's all there.
I made it through 10th grade. I'll be all right.
Yep, you'll be all right.
In West Virginia. No, I'm just kidding.
Yep. All right.
Just because you're dressed up doesn't put you higher than me, Summer.
When it comes to today's standards, Randy, what would you say from a legal standpoint? Where has our legal system gone astray or outright violated the Second Amendment, in your opinion?
Well, let me start off by saying the reason why we have a right to keep and bear arms has very little to do with the courts. We have the right to keep and bear arms because we have been a gun-possessing nation of citizens who valued that right. And generally speaking, that right was protected politically. It was not protected judicially. And I would say that until pretty recently, most of the gun laws that were passed that passed political scrutiny were what you would call reasonable regulations of firearms. Maybe not every single one, but most of them were. It was only in the 60s, as I said, where there became an organized movement for the first time to disarm the American people. That was the objective. Starting with handguns in the so-called Saturday night specials, which were inexpensive handguns. Right. The idea here was we need to come up with any way we can, any excuse we can to disarm the American people because we don't like guns. And we also don't like the idea of an armed public either. They didn't like that either. And so I think the biggest problem in this area is that the courts, when they finally did get into the act, and that begins with the Heller case, have been inadequately skeptical about the regulations that have been passed under the rubric of being reasonable regulations, which are in fact motivated by a desire to either raise the cost of gun ownership to the point where it's prohibitive, or to essentially disrespect or delegitimate the right to keep and bear arms, to make it as hard as exercise this as possible. And that's not the way constitutional rights are supposed to work.
And I also think there's a real strategy of incrementalism there too, where it's a little bit of reasonable regulation at a time until you have no rights left. I do think that is a clear strategy of the left. I don't know what your feelings are on that, or if you even want to comment on that. But that is something that is always, I see that it's not just in gun regulation. We see that with every civil liberty that we have, everything from freedom of speech to you name it. That's taking place. And we definitely see it with the Fourth Amendment, what's going on with privacy these days. It's a little bit at a time, and we are, there's a clear strategy in my mind that we are trying to normalize or condition people to just not have rights. That's what it looks like to me. But I don't think there's any question about it. And they basically, and really all political actors do this. This is not nefarious. They basically try to pitch something that they think they can sell. And it's easier to sell something at the margin than it is to sell something all the way down to that's very extreme. So they just try to take a little nip at a time, because you can't object to that little nip, can you? And what about this little nip then? And you got that little nip there. And so it's a reasonable strategy for how you accomplish what is their long-term strategy, contrary to the fact that so many of them now deny that this is their strategy, but I don't believe them, which is essentially to disarm the American people. 100%. And so that we're like other countries in this regard. Now, what is your thoughts on if the NFA ever came up before the Supreme Court? Do you ever think it will? Do you think we'll ever see a change in the NFA, and as well as the 1986 laws? What is your thoughts on that going forward?
I've read people who seem, and I've watched some YouTubers who I like very much, by the way, sure. Who have been arguing that the NFA may be subject to, may be ripe for a constitutional challenge. As somebody who's argued in the Supreme Court, the medical marijuana case that came out of California in the 2000s, that's my only case I argued in the Supreme Court, but I lost that case 6-3. When I lost Justice Scalia and I lost Justice Kennedy on that case, I got Rehnquist, I got O'Connor, and I got Thomas. For medical marijuana, that was pretty good.
Yeah.
But I think I'm not optimistic that this court would be very welcoming to any kind of challenge like that. I'm going to be as candid as I can be. I know the justices myself, and the only justice that I haven't met is Justice Jackson, the most recent justice. Some of them I know better than others. I like them as individuals. But some of them are more hardcore than others, and there are a few of them that we have it. I want to say we have a conservative Supreme Court, and if it weren't for the election of 2016, we would not have a conservative Supreme Court.
Right.
And we have six conservatives. John Roberts is a conservative as well, even though he voted against us. He pulled the legs out from under us in the Affordable Care Act.
Is Sino a phrase? Conservative in name only? I don't know.
He is not a liberal. He's not a progressive. He's a conservative, but
Sure.
he doesn't. But he's not an originalist, and he's never claimed to be an originalist. He's an old school conservative that argued for judicial restraint. When I was coming up, let me just digress here for a minute. When I was coming up through the conservative legal movement, I'm a libertarian politically, but I'm a full-blooded member of what's called the conservative legal movement. When I came up in the conservative legal movement, most conservatives were advocates of judicial restraint, or what President Bush liked to call "don't legislate from the bench."
Right.
And that means they were very upset about courts invalidating popularly enacted laws. Now, of course, they had in mind the Warren Court and what the Warren Court was doing with popularly enacted laws, but that's why they favored judicial restraint over so-called judicial activism, which is striking down court laws. Well, but you see, when it comes time to enforce the Constitution, we need the court to hold on unconstitutional restrictions on our liberty. We don't want judicial restraint. And the excuse that Justice Roberts gave for upholding the individual mandate was judicial restraint. He said, yes, the best reading of the statute is it's an individual mandate to buy insurance, and it's a requirement to buy insurance. And if it were such a thing, it would be unconstitutional. But I can interpret it as a tax because it only involved a small monetary amount, and it's being collected by the IRS. And I have a duty to interpret it as a tax, even though that's not its most natural reading, because I need to defer. That's old school judicial conservatism, deference. But since the rise of originalism, and this really only started to take hold during the Trump administration, when they were picking judges, they were looking for originalist judges, not restraint judges. And they found a lot of them. But we don't have a full complement on the Supreme Court. This is why originalism is important. And why we need to. So going back to your question, I would be skeptical that we have 5 justices who are prepared to do anything about our existing federal gun regulatory scheme. I think if we're lucky, and I wouldn't take this for granted, I wouldn't take it to the bank, they're going to strike down restrictions on AR-15s, and they will invalidate restrictions on standard capacity magazines of the same kind that law enforcement is entitled to use. If we're lucky, they'll strike down those new laws, but I don't see them priming. They're not. First of all, they're not doing it yet, are they? They're taking their sweet time to intervene in the Ninth Circuit and other circuits that are doing these things, the Seventh Circuit as well. I think maybe eventually they'll do it. But this does not encourage me that they're at all receptive to do anything more than that.
So are you saying that you think that they won't even hear a case regarding the NFA, or that they would hear it and
the only way they will ever, if I'm right, and look, I hope I'm wrong, and I'm not the biggest Supreme Court soothsayer around, so don't get too upset with what my predictions are.
This is all speculation.
Yeah, but I mean, if the only way they would even consider the case is if you win at the lower court, you've got to win in a circuit somewhere. Some Circuit Court of Appeals panel of 3 justices has to rule against the NFA, and then that has to be upheld en banc if it's appealed en banc, depending on what circuit you're in, whether you can survive en banc. And only if the act is invalidated will they take the case up. They'll never take the case up if it's been upheld below, in my opinion.
I wish they would.
Yeah, I do too. And it'll be a matter of, someone determining some sort of standing, which I guess probably wouldn't be that hard. I'm sure there's folks out there that have been charged with crimes. Obviously, they have with the NFA Act, and we're seeing more and more, FFL and Class 3 dealers that are getting hit by the ATF. But speaking of the ATF, kind of going back, and I know there's probably nothing that will be done, definitely not in the immediate. But what do you think that the founders Do you think the founders ever envisioned something like the ATF, and what would their view on such an agency be today?
Well,
question.
the ATF is a federal agency, and I just told you that the Second Amendment applies to the federal government. So it is a good founder's question, as opposed to oftentimes I'm saying, no, well, let's ask what the Republicans would have done, because they're the ones that gave us the 14th Amendment. Although that sounds a lot more like original intent. I'm actually a public meaning guy, not intent guy.
Right.
But look, the entire scale of our federal government is something that was never anticipated or favored, even by the most nationalist
That's
of
what
the
I was
founders.
thinking.
The founders disagreed about a lot of these things. There was not, it was immediately a conflict between the Federalist Party, what became the Federalist Party, and the people that were originally anti-federalist, but eventually were called Republicans, the Jeffersonian Republican Party, resulting in a lot of federal legislation passed under the Adams administration, Washington Adams administration, and that resulted in what was called the Revolution of 1800 that swept Jefferson into power by people who were opposed to that sweeping amount of federal authority. But this only goes to show that this debate over how broad the federal powers should be goes all the way back to the beginning. But even the most nationalist of federalists, I think, would have been aghast at the size and scope of the federal government today.
Yeah, and I think the problem with a lot of these laws get passed with the idea that, hey, we're going to stop crime, and that's what they're sold as, and that's what they say. We're going to stop these
All
criminals
for the greater good.
Well, the
For
idea,
you all.
the idea is they're going to focus
You
on,
all.
on specific crimes,
Right.
crimes that are going to appeal to everyone's emotional reaction. Like, oh, we've got to stop murders. We've got to
Right.
stop gangsters. We got to
That's what I'm
stop this, all these things. Right. But then what happens is, and what I see more, especially what I feel like that's happening more with the Biden administration, is that, it's a lot easier. It's a lot less challenging when you're going after store owners, when you're going after these people for these small things. It puts people to work because it's a lot harder to go after criminals. It's a lot harder to go after these hardened criminals that are smart, that know the laws a lot better than a lot of times the average law-abiding citizen does. They don't know their rights. Whereas, most of the criminals, especially if they're good at crime, they're pretty smart.
Most criminals are pretty stupid.
Yeah.
I've
Then you have some that are absolutely
he's
brilliant.
Now it is true. It is true that the criminals that I came across when I was a prosecutor in Chicago were the ones that got caught. So you could say it's a selected group of stupid ones. But I got to, as part of my duties as a prosecutor was to question suspects in the police stations in the middle of the night in the Chicago Police Department police stations. And so I got to talk to a lot of them, and I do want to say one of the lessons of this, and this is actually going to be in my next book called Felony Review, which is going to be about my experience as a prosecutor. That's not in this book. But one of the things that I learned is that there's a diversity of criminals. There's all kinds of criminals.
Sure.
Some of them are just ordinary people that have they can make more money this way than that way. Usually selling drugs, for example. It's a more lucrative business than other businesses they can do. But some of them are really, really bad, to the point where other criminals are really afraid of them. And so they're diverse, but they're usually not that smart. They're just not that smart.
I would say you got to buy a sample, though.
It
Well,
is a
that's
bias.
No,
Well, there's the one thing I said back. And I'm sorry to interrupt you, Chris, but
No,
the
you're
one
fine.
thing. The one thing I said back in the day is when I was a prosecutor, I said, look, if criminals would just wear masks and commit crimes outside their own neighborhood where they could be recognized, we would probably not solve any crimes.
Yeah.
Well,
And then not talk to the police, to the police when they get arrested. That's the third
kind of
thing.
where I was going. It was just like, these guys are just, you don't catch the good ones ever. But I was just like, these people have to just be morally effed in the head to be able to do some of the stuff that I'm sure you saw in a major city, because we're here in Hotung, West Virginia. You don't see that. You see it once every 5 years. But that's got to be an interesting book.
Mm-hmm.
That's going to be an interesting
one story I'm going to tell in that book is a story about how I had to carry, because it was not legal for me to carry in Chicago. Even as a prosecutor, I couldn't do it. But one of the things I did, one of the cases that I worked on is in the middle of the night in the police station, I took confessions from 2 of the 4 gang members, Latin King gang members, who had stabbed to death these 3 suburban kids that had driven into Chicago to try to buy marijuana. It's a long story about how this happened. The gang members didn't have any marijuana, but then the kids that were trying to buy the marijuana thought the gang members didn't trust them. So they started talking about all the Latin Eagles that they knew, but they didn't realize they were talking to the Latin Kings, not to the Latin Eagles. They're their rival.
Oops.
And so the Latin Kings then took them out into the, they said, oh, we know where we got marijuana for you. They took them in their own car. They drove into this alley and stabbed all 3 of these kids to death. And I took the confessions from 2 of the 4 of these. And so I didn't prosecute the case because I was actually a witness for the prosecution in the case. And so when it came time to try the case and I was going to be called because I had to testify to the confession that I took from them, we got word to meet with members of the people, representatives of the Cook County Jail, and to sit down and tell us that according to the informants they had at the jail, a hit had been put out by the Latin Kings on the judge and the prosecutors in the case, on the theory that no Latin King was going to get the death penalty. This was a death penalty case. And so, of course, I was not a prosecutor in the case. I was a witness, but I couldn't get a declaratory judgment from the Latin Kings as to whether I was in or out of their hit. And so I lived in gang territory at the time, and I foolishly had my name listed in the phone book back in the days when there were phone books. And so I thought to myself, I think this is bullshit. I don't think that this is real. I don't really feel endangered. But on the other hand, if I'm walking home at night, having parked my car on the street, and I'm walking up to my apartment on the north side of Chicago, and a drive-by happens, and they come shooting at me, and I got nothing in my hands, I cannot fight back. What an idiot I'll feel like. So I thought, well, I better do something. And so what could I do? Well, at the time I was a felony trial assistant, and in my drawer in my office, I had a drawer full of very nice guns that had been evidence in various crimes that I had prosecuted. And I had not, and it was my job to see that they were destroyed. And I could not bring myself to destroy them. So they were just sort of sitting there. And I thought, well, I could take one of those. But the problem with those is they'd already been through the Chicago Police Department crime lab. They had crime labs serial numbers etched on them. And it would have been illegal enough for me to have a gun. But on top of that, I'd be carrying something that had been evidence in a criminal case. So that wasn't going to work. So instead, I went to my parents' house, and I borrowed my father's Smith & Wesson revolver, which he used when he trained me to use, or he had me learn how to use when he was working himself on the south side of Chicago. It's the Smith & Wesson that has the shrouded hammer, so that you can keep it in your pocket and it won't catch on the material when you pull it out. And so I took it, I borrowed it from him, and then I took it to a range because I hadn't fired it for years. And my brother remembered, I forgot this story, but my brother remembered that the range was full and they said they couldn't accommodate me. And then I told them, but I was a Cook County State's attorney and I needed to do this. And they said, okay, fine, we'll make room for you. And so I fired it, and I carried it for a couple of weeks in and out of court and in my briefcase. And nothing happened as I expected.
Carried it
nothing
in court
would happen.
too, huh?
I carried it into the courthouse.
Yeah.
And so, and in those days, attorneys didn't have to go through the metal detector. So I was able to carry it in and out. So at any rate, that was my experience illegally carrying in Chicago because I didn't want to be caught empty-handed.
I just think he pronounced badass wrong.
Well, the real thing here is
like
that you were exercising prosecutorial discretion. That's what
Is that a real word?
It is. Yeah.
It is.
He decided not to prosecute himself.
As long as you can spell that for me, Gary, you know what?
I sure can,
You
buddy.
spell it for me after the show.
Oh, that's great. No, I love it, man.
That's awesome. No.
Kudos to you,
I got a
Randy. Controversial question for you.
Oh.
And this is something that I firmly believe, and I would like to see. I would like to see you prove me wrong.
Here we go.
And if I am wrong, I'd be happy to admit
I might take the fifth, Gary.
that's fine.
You would be
He's
happy
probably an
to
expert
admit
on
that
it,
you're
too.
wrong?
So I would like to
That would be a
see what your
first.
thoughts are as far as here's what I believe. I've read through the Constitution, looking through it for this. I've done a little bit of law research on this. I haven't found,
Sounded out most words.
Ultimately, the Second Amendment is a right, and those rights are granted to us. Those are natural rights. And where did it start to where we decided that felons were now denied that right?
Oh.
My thought process on this, and I know a lot of people in the Second Amendment group are going to disagree with me, but either rights are rights or they're not. And my thought on this is like, hey, you know what? If you committed a crime You go to jail for that. If you're so dangerous that you can't exercise your rights, then we need to keep you in jail. But once you are out of jail or prison and you have done your time, you've done whatever you need to do, you know what? You should be given all of your God-granted rights back, because the U.S. government does not have the right to take those rights
just
from
like they
you.
don't have the right to grant it.
Just exactly that. You know, though the Constitution is a bulwark to withhold the government from trampling on your rights.
That's solid. That's
what
solid.
what is the legal philosophy behind, or where did those laws come from that said, hey, you know what, once you've committed a felony, and unfortunately this goes with all felonies, even if it's not a violent crime, which I think is especially harmful to most people, taking away their ability to defend themselves. So talk to me a little bit about that, Randy. Tell me where I'm right, where wrong. Where is that constitutionally?
I mean,
Well, I respect that view that you've expressed, Gary, and you may very well be right. But let me point out a couple things. First of all, at the time of the founding, felonies were by and large death penalty cases. I mean, felonies were punished by death. We didn't have prisons at that time. The prison movement was a reform movement that came into effect in the 19th century. And so most felonies were death penalty events. So there was the idea that felons would be dispossessed of rights really was kind of moot, because they could be dispossessed of all their rights if they were felons.
Sure.
So that's kind of what was happening at the founding. But subsequently, the category of felonies was expanded. And I know that, fast forwarding to, the current situation, Justice Barrett, when she was on the Seventh Circuit Court of Appeals, before she became on the Supreme Court, wrote an opinion for the Seventh Circuit arguing that the only felonies that ought to count. Now, this is not your position, because your position is once you're out, you're out. But her position was that the only felonies that ought to justify any kind of disarmament are felonies that demonstrated a willingness to harm others, dangerous felons. So all the other felonies, all the bookkeeping felonies and the other technical felonies,
I think that would be more reasonable for sure.
She argued that those should not disqualify people. And I do think that there is a case up this year that is going to touch upon this, and we'll have to see. The decisions are going to start coming down pretty soon, and we'll have to see what they say. I think that the court may actually come down somewhere close to that. So they're not going to go all the way and say, if you're out, you're out. But I think they may go to the point where and partly because she's already there, and that's one more vote, they may go to the point where they say, you're going to have to be adjudicated as dangerous before you can before your right to bear arms can be restricted. And they may not say everything that needs to be said about that. Like, for one thing, what is due process when you're having one of these adjudications? It can't just be a what you might call an ex parte, or one person makes a complaint. These are what these red flag laws are doing. And then your guns get taken away from you. There has to be some real adjudication of dangerousness. And I think that something like that is going to possibly happen this year. There'll be some restriction on that, but we'll have to see.
Now, I mean, just on the face of that discussion, where in the Constitution did they find the authority to be able to remove those rights once a conviction has been taken place?
Ooh.
Well, I mean, none of this is what's in the Constitution is that we have constitutional rights. And I knew we were going to get here eventually. And I've been thinking for the last week or two, building up to the show, how I was going to break this to you, because I know that at this point you have a high opinion of me, but I think what I'm about to say next is going to
have feelings, Randy. You
yeah,
can't hurt them.
What I'm about to say next may disillusion you about me and also the people in the comment section. So here's what I think. I think that all constitutional rights can be regulated, including the right of freedom of speech can be regulated. And let me give you an example of a regulation of the right of freedom of speech. And that is what are called time, place, and manner regulations of speech, that you should not be able to put a huge speaker on the top of your car and drive through a residential neighborhood and blare out what it is that you wanted people to know in the middle of the night in your town. I think that it is a reasonable restriction on your right of free speech that's a reasonable, not a restriction, that's a reasonable regulation
Sure.
of how you go about exercising speech.
It's also
So if you can do that, if you can do that with speech, you can do that with the right to keep and bear arms as well. But here's the thing. So you say, well, what is it about a constitutional right that you don't understand? It's a right. If it's a right, it's a right. Well, I don't think constitutional rights necessarily work to defeat all laws. I think the function of constitutional rights is to put the burden on the government to establish the necessity of that law law is not just necessary in some general abstract way, but it's necessary to serve one of the principal functions of government, which is to protect each of us from each other. The first duty of government is to protect our natural rights from each other. We leave the state of nature in part under this theory of social contract. We leave the state of nature in part because we believe we cannot protect our own rights against everybody else in the world as well as we can with a central authority that has an executive power to help protect our rights for us. Now, that may prove to be false, that the government isn't protecting our rights very well, and that's a violation of the social contract if they're not. Speaking of the social contract metaphorically here. But the first duty of government is to protect us from each other. Then, having empowered a government powerful enough to protect us from each other, we then need a constitution to protect us from the government, because we've now created a power that it becomes a threat independently of each other. So when you ask where in the Constitution is there a right to any particular regulation of our liberties, it comes from the general power of government. In the case of the federal government, it's limited and enumerated powers. In the case of state governments, it's more general police powers to protect the rights of each of us from being aggressed against by our fellow citizens and non-citizens.
And by the government.
Well, that's the power they have. And now we also need constraints on their power so they don't use the power that we've given them to do this one thing to do things that they shouldn't be doing, like taking away our rights.
So basically, the government was established to protect the people's rights from each other. And then we had to also put restrictions on the government then after that to restrict them from taking away our rights.
Exactly.
Yes.
Yeah.
That's it. Summer, why didn't you? Well, you should have interrupted me and just said that. We would have saved us all a lot of time if you'd have just said that.
That does.
You let me go on. You let me go on. You let me go on and on.
It took me all that time to formulate it in my mind. No,
Yeah, that's deep.
The only problem I see with that is that it does leave a lot of subjectivity out there, and there's always obviously going to be some. What is reasonable? What is it? Because you're absolutely right. There's obviously
saying it doesn't leave a lot of subjectivity.
No, it does. It leaves a lot of subjectivity.
I was like, yes, it does.
Yes.
That's why I don't.
And I get it. And I get the fact of the matter is that we also have a lot of laws that I don't think have ever been challenged constitutionally, and maybe for good reason or not.
Let me begin. I think, even though it is accurate, and you'll hear me saying it too, that that reasonable regulation of constitutional rights is permissible because of the police powers of states to protect us from each other. Reasonable is not enough. Reasonable is not good enough for the precise reason, Gary, that you identified. It's too subjective. There's going to have to be more than saying, oh, well, that's reasonable. If I think I'm a reasonable person, if I think it's reasonable, then it's reasonable. That's the kind of debate we get into with the gun controllers. 100%. Well, why would anybody need this? And why would anybody? This is just a reasonable restriction. You're reasonable. I'm reasonable.
Yeah.
Who needs that? I think that's not good enough. I think there has to be a demonstrable and empirical established connection between a restriction of our liberties and one of the core functions of government, which is primarily to protect each of us from each other. I do think that can exist in the case of, for example, people who are mentally deranged.
Sure.
People who just cannot be trusted to manage their own affairs and pose a serious risk of harm to other people. We have in this country a history, a tradition of committing people involuntarily, civil commitment and sometimes criminal commitment, because they are deranged, and people like that should not be necessarily out in public with firearms. Mm-hmm. And I think most of us would agree with that. Now, that is what I'm calling a regulation I will call that a permissible regulation. it's also reasonable, but it's reasonable only because it connects up with a core purpose of government is to protect each of us from each other. And there's got to be due process. There's got to be an adjudication with evidence. Somebody can't just come in, well, that guy's crazy, take his guns away. There's got to be more than that. And that's what the due process of law is about. And you'll notice that the 14th Amendment that you read out loud earlier in the show protects says that no person's life, liberty, or property can be taken away without the provision of due process of law. That's another requirement. After you've identified the rights that we have, then you have to identify what is the due process that we're all entitled to before those rights can be before those rights can be regulated or restricted.
Well, and that's where even due process itself becomes subjective when you're talking about, red flag laws and things like that, because essentially that is what we're seeing with these red flag laws. We have, one witness, one person, a restraining order, whatever it is, where now suddenly states are regulating the idea or have put into law the idea that, hey, based on one person's testimony with very little due process, definitely have not been convicted of any crime, that now we can go in and seize their weapons.
Well, I just think there are examples of people who seem to pose and I would say this is not based on just things they say. These are based on a long course of conduct in which they've manifested grave threats to other people. They've made threats. They've done things. This is not wonderful. I mean, it's not perfect. But as you say, you could call it subjective, but we do have to be able to protect ourselves from people who are dangerous individuals. Generally speaking, the way we do that is we wait until they commit a crime and then we prosecute them for it and then we punish them for it, or we incarcerate them as a result of that. That's what we generally do. But there may be situations in which they are demonstrably dangerous. But I say demonstrably, I mean you need to demonstrate it. It's not enough to accuse people of it.
I agree with that, and I have no issues with that. Again, ultimately, though, we have some of these. I've read several situations, even in Maryland, where, again, it's a matter of he said, she said. There hasn't been any sort of, behavior set forth. It was, this person said this person was dangerous. So now they're going in and seizing guns and things like that.
I mean, we've personally known people that have contacted us and said, hey, going through a divorce, my ex-wife went to the court and said I was a danger, and they came and seized all his weapons
with no proof.
With no proof whatsoever. Just his ex-wife saying
these are under challenge. These are being challenged.
Yeah.
The case that's in the Supreme Court has something to do with that, right? This year, and so I think that's wrong. I think that courts issue these called orders of protection all the time. They're done routinely. And there's no due process involved. And the judge is going to say, "Oh, nothing to lose. Just leave this person alone. I order you to leave this person alone." Well, that can't be a justification for the deprivation of a constitutional right. It just can't be. And those are under challenge. And I think I'm guardedly optimistic. I don't get too optimistic about the Supreme Court, I have to tell you, but I'm guardedly optimistic that they might step in and protect us from that. I just want to point out to TC here, mentally deranged, that's 3/4 of Washington, D.C., he said. There's a reason why I no longer live in the District of Columbia. I now live in the free state of Florida. And when I'm not in the free state of Florida, I'm in Central Virginia, where the normies live.
There we go. That's what I'm talking about.
Is Trump derangement syndrome enough to take your guns? One of the things, just going back to the Supreme Court and kind of what we're talking about with that, and I think the legal system in general, one of the things I do find or have observed, it seems like even the most conservative, maybe even the most libertarian of legal minds out there seem to be, or at least it's my impression, they seem to be sort of indifferent on the Second Amendment. And I that has been
who's indifferent? Who's indifferent?
The Supreme Court, people in the legal system, when it comes to the Second Amendment, it seems to me that even the most conservative, judges out there, even I would say even lawyers and things like that, people in the legal system, the conversations that I've had and just observing, things that have been issued by the Supreme Court and everything else, there almost seems to be an indifference to the Second Amendment. What's your thoughts or impressions on that?
I suppose that's true. I suppose that's true of my colleagues. And of course, my colleagues are probably hostile. They're not even indifferent. There are conservative judges who are really not good on this. Frank Easterbrook on the Seventh Circuit Court of Appeals, somebody I know from back when he was a law professor at Chicago before he went on the court, is terrible, awful, terrible on the Second Amendment. He's upheld every law that came before him, even after Heller. There are conservative judges who are like that. Those are the old school restraint judges, I should tell you. In fact, there was a very famous, J. Harvey Wilkerson is a very famous Court of Appeal, Circuit Court judge in the Fourth Circuit, who argued that Heller, he was conservative, and he argued that Heller was judicial activism because they're invalidating laws. Remember what I said back in the earlier part of the show, that that's old school conservatism, is you shouldn't invalidate publicly enacted laws. But of course, what we're sitting here thinking now, we're sitting here all agreeing about with amongst ourselves now, is we have a constitutional right. That means you should invalidate laws.
No,
Right.
and
Exactly.
and I've complained about judges legislating from the bench, but essentially
judicial-
that's what I'm advocating for at this moment.
The judicial
But
system is a check and balance of the legislative system. So if there is a law put in place that is unconstitutional, it should be stricken down by.
Well, Summer is right again, and
Whoa!
Who would've
We gotta
thought?
we gotta slow our roll, Randy.
Who would've
I know. I can't help it. She happens to got 2 out of 2.
Yeah.
But this is exactly why there's a turn that got taken in the conservative legal movement, and I date the turn to the Affordable Care Act a defeat, because up until that point, all Republican presidents who are picking more conservative judges are picking judges because they claim to be restrained. Then in 2012, we got the Obamacare case in which restraint is what John Roberts was doing.
Right.
And after that, the next Republican president to come along was Donald Trump. And it was only in the Trump administration for 4 years was the White House screening for judges who were originalists and who would stand up to the legislature and hold things unconstitutional. We've only had 4 years of Republican presidents picking conservative judges who had that mindset. Now, they didn't get them all right.
Ever?
Yeah.
You're saying ever. Yeah.
Yeah. In our lifetime.
Well,
Randy, you're only have what 48 years old, 53 years old, so that's a short time.
I am so old. I am so old.
Don't even give me that. Don't
that
even
when
give me
I-
that BS.
that when I-
Randy was actually part of the original militia.
Yeah. I was so old that when I was 12 years old, I got up in front of my entire grade school and junior high school student body and debated on behalf of Barry Goldwater in the 1964 presidential election in a very Democrat working class town called Calumet City, Illinois. That's in my memoir. So I'm on record. I also decided I would read to you because the name of this podcast is Dangerous Liberty, right? Is that the name
That's
of it?
correct.
100%.
All right. So I wanted to read to you the first article I ever had published, which is in the book. It's in this book. And this was published in the Hoover Highlights. I went to Hoover School. This was in March 1st, 1962. And here's what I wrote in my first published article. The title was Be Patriotic. And here's what it said. Washington believed in a democracy. He was thankful for liberty. We don't appreciate liberty like he did. To us, it just comes natural. We should be more patriotic for what our forefathers fought for and won. And then in all caps, liberty. So that was me at the age of 10 years old. That was my first published article. So I've been on brand. I've been a dangerous libertarian ever since then.
Oh.
That's awesome. No, going back to the idea of judicial restraint, I will also say that it was kind of a response because it happened almost always on the left when we had legislation from the bench. We didn't see that on the right, where you found, somehow we were able to find abortion in the Constitution. We were able to find, that was something that was very common on the left. They were winning these political fights through judicial activism. So when you had George Bush, and this is just me talking, by the way, folks, I'm not saying this is fact, but when you had George Bush talking about, and conservatives in general.
Which one?
Both of them.
Okay.
Any of them.
Okay.
When conservatives in general talking about, judicial restraint, and not legislating from the bench. That was directed one way because that was only coming from one direction. Do you agree with that, Randy, or am I completely wrong?
Yeah, because the courts were at that point dominated by progressives. Not the hard left. I distinguish between liberals or progressives, liberals and the hard left. Liberals, like Alan Dershowitz, my professor, is a liberal, and he also believes in civil liberties and he believes in liberty. He's not a libertarian. He's not a conservative, but those are old school liberals. Then we have the leftists who are the ones that are coming in, but the liberals dominated the court, as you say. I'm agreeing with you. And they were invalidating all kinds of laws that they didn't like, and they may not have had good constitutional reasons to do so. And that really should have been the reason we objected to it. Not because they were invalidating a law, but because they didn't have an adequate basis to
100%.
invalidate the law.
That's
but it
my
was an easier thing for politicians to argue that you just shouldn't invalidate laws. You can get in front of a microphone whenever a law gets invalidated that you like, and you can say, oh, that's judicial activism. And you don't have to know anything about the Constitution or the reason why it might have been invalid. You can just say you shouldn't invalidate laws. That was too easy. I don't say we, because I was always on the other side of this battle. But I was in the minority, and now I am in a greater majority, I think, among the judicial conservatives. But what I'm saying is that we got that. Conservatives got that from the progressives. It was the progressives who objected to the Supreme Court protecting property rights and other rights before the New Deal. And that was the progressives who were criticizing the judicial activism of the conservative court. And then political conservatives just picked that up and became part of their toolkit against the activist liberals, the activist progressives.
No, it makes perfect sense. Yep. I think now's a good time. Sean, let's throw up some viewer questions up there.
I'm ready.
This is a great question. Do non-citizens have a right to bear arms if we rely on the privileges or immunities clause for incorporation?
I think the answer is not directly. Constitutional rights really adhere to citizens unless they are applying to persons. Some of the Bill of Rights do apply to persons. But you'll notice that the Due Process Clause and the Equal Protection Clause also apply to persons. They're not limited to citizens. And so if you take a non-citizen, they're still going to have due process before their life, liberty, or property, which are their fundamental natural rights, can be deprived of. And that means that such a law would have to be would have to bear a significantly rational relationship to one of these core government purposes we talked about before. But it would not be irrational on the basis of the text of the Constitution to distinguish between the rights of non-citizens and the rights of citizens when it comes to things like this.
Yeah, so,
What?
Randy just blew my mind. I have zero rebuttal.
Well,
You're 100% right. I mean, he's right.
okay, so where do those distinguish? Where do we distinguish which rights apply to non-citizens and which rights don't?
They have due process clause rights,
right?
And there are other federal guarantees about most of what the Bill of Rights concerns criminal procedure, and those rights apply to persons.
So what I'm gathering is, if we consider the right to bear arms or the right to defend yourself a natural right.
The right to defend yourself is a natural right.
So
the right to,
a non-citizen would have that right, and they have the right to due process for you to be able to remove that.
Remove that, yeah. If they didn't do anything wrong,
that's what I'm taking from what you said.
I'm taking if they didn't do anything wrong.
Gary,
you'll always hear the argument for me that I think that number one, I think what we do have is that we have criminal immigrants do not have the right to be here. With that being said, any person globally, in my opinion, has the right to bear arms.
Okay.
Now again,
you put criminal and immigrant in the first sentence, but you didn't just say immigrant at all.
Because there's a difference.
There is, but you didn't say immigrant in any of the sentences you said. You said criminal immigrant.
That includes the word immigrant.
I know, but not all of them are criminal immigrants.
No.
Question referred to just
number one, if you come across the border illegally, you don't have the right to be here.
That's not a criminal immigrant.
But if you are here, I think even if you're here illegally, you should have the right to bear arms.
Do you think there's a difference for somebody crossing the border in Canada than Mexico?
No, I don't. If you come in illegally,
Do you think the public views it differently?
I don't care if they do.
No,
just
I'm
saying,
asking you a question.
They do
you
view it
think-
differently.
I'm sure they
Correct.
do.
Yeah.
I'm sure they do. But
I know, but
if they
that's-
come in, if you come in illegally, I don't know what you're arguing with me about.
You said criminal immigrants,
I think what he's going
I-
back
I
to, and
guess-
he's not explaining, is that the question was non-citizens.
non-citizens.
Non-citizens should have the right to bear arms.
There you go.
Correct. That's where I'm at. But
Criminal-
you went criminal.
criminal
straight up,
immigrants-
like your first sentence was
But
criminal.
I think that's where that was going, and maybe I'm just assuming.
You're
Okay.
assuming. I think
That's
you're
fine.
assuming.
I
But
see what
we've
you're at.
talked about this on the podcast before.
Sure,
and I
yeah.
thought
that's why I was going at it. Yeah.
So, I mean, I think everybody has the right to bear arms until you've done something that you are adjudicated by taking that right away.
100%.
Now, I also agree with the fact that you shouldn't be in this country illegally to begin with, but that still
But
doesn't limit your right to protect
So then
yourself.
that
for my
bears-
God-given right. Correct.
For me, that bears the question: if you're in this country illegally and you're prosecuted as such, found guilty as such, I guess depending on whether is that then what you consider a due process to take away that right to bear
I
arms?
don't even think that's.
I
I
think
don't
so.
even think that. I don't even know that. And again, we're sitting here lawyering it up on the.
I know.
On the
Loaded up
In
on
front
a
of the
lawyer.
while we
lawyers, he's
have a legal
observing and
scholar over
listening.
We're just throwing opinions out. and he's
like,
just
listen
sitting there.
to these-
He's like,
listen to these
these
newbies.
are
Like,
idiots.
Is this over yet?
These are like he's like, this was like the drunk conversations I had in my first year
Yeah,
of law.
he's like, I can't even take a sip of my whiskey.
Randy,
right
take it from there.
I'm going to move. Let's move on to the next question, you guys.
There he is. There's the drink of the whiskey.
What are the most prevalent misinterpretations that you see that you speak out against?
Oh, there we go.
Well,
Misinterpretations of the Second Amendment, I'm assuming.
I don't.
I would hope.
Yeah.
I don't know.
Otherwise,
I have the Constitution has a lot of clauses, and there's a lot of stuff to know, and I am not an expert on it. Because I teach constitutional law doesn't make me an expert on every aspect of the Constitution. I'm a scholar in some areas and not others. So the ones that I know about and the ones that I spend the most time thinking about are the right to keep and bear arms. That's one of them. That's an obvious place where lower courts now are in an active civil disobedience against the Supreme Court after the Bruin case, and they just are refusing to follow the Bruin case. And I have my own qualms about how Bruin was reasoned, but I nevertheless think that under our theory, the lower courts, the inferior courts, should be following what the Supreme Court said in good faith, and many of them are not. So that's a big problem. And the other problem we have is an overpowering federal government that's exercising its power under the Commerce Clause and the Necessary and Proper Clause way beyond where it ought to be, which is what was involved in both the Raich medical marijuana case that I litigated and the NFIB Obamacare case that I was part of. And that means that Congress has a power to regulate commerce with foreign nations and among the several states, with Indian tribes and among the several states and with foreign nations. Those are the three commerce powers it has, and it does not have the power to regulate commerce even inside a state. There is another clause, which is overly used, called the Necessary and Proper Clause, that says Congress has the power to make all laws which shall be necessary and proper for carrying into execution its foregoing powers, like the commerce power. But there needs to be limits on the Necessary and Proper Clause for it not to overwhelm all of the states, the powers that are reserved to the states by virtue of the enumeration of powers to the federal government. So that's another restriction on federal power that is not enforced to the degree it should be. But those are the two there may be some other areas I'm not thinking about now, but those are the ones that I spend the most time on as a scholar and even as a lawyer.
Now, Randy, is there any recourse against these courts that are just, flagrantly defying the Supreme Court's ruling on many of these cases?
The Supreme Court has to step up and protect itself. If it won't step up to protect itself, there's not much we can do about it. That's not much any of us can do about it. We just keep litigating these things and hoping the Supreme Court will take some of these cases, and then they'll do the right thing when they do. For a long time, we blamed Justice Kennedy as a swing vote that didn't want to do these things, and you could blame Justice Roberts, but I'm not actually sure who's up there letting this stuff go on. I don't know which of the justices are the weak link when it comes to the right to keep and bear arms, but there's got to be a weak link up there, or presumably they'd be more aggressive in protecting their turf from disobedient lower courts. I just don't know I don't know the answer as to exactly what the dynamic is up there that's leading them to be so passive in the face of resistance by lower courts.
Now, does the Supreme Court have any authority to, to I don't know, to do anything against these lower courts that are clearly defying the orders?
They have the power of judicial review, and they can vacate lower court opinions, and they will do that. They do that, but they I guess they don't want to bite off more than they can chew, and they're only willing to go incrementally. And I will say, I mean, one of the things that I do talk about in my memoir is about how when the 2016 election was happening, and this was after Justice Scalia had passed away, there was an open seat on the Supreme Court because of Speaker McConnell. The Republicans in the Senate said, we're not going to consider any replacement nominated by President Obama until after the election. And so the election really came down to where the Supreme Court was going to be for the rest of my life. And I fully expected Hillary Clinton to win and Donald Trump to lose. I believed the polls. I didn't necessarily think that he had such a great campaign. I didn't realize she had such a terrible one. But the point is I was expecting he would lose, in which case she would fill that seat. And that would be it for the Constitution, as far as I'm concerned. And I was at that point intending to leave constitutional law myself, go back to teaching contract law, and retire. I would have been retired by now, because it would be no longer have been worth the fight anymore, because we would have lost. And it's only because Donald Trump won that election. And then he honored the promise that he made, which I also didn't have much confidence in, but he did honor the promise he made to appoint originalist judges.
Yeah.
And then he got a White House counsel, Don McGahn, who rigorously tried to screen for originalist judges, that we basically saved the Republic. The Republic was saved as of 2016. Now, 2020 came along, and now we have a whole slew of Democrat non-originalist judges being put on the lower courts and on the Supreme Court as well. But I believe we could withstand 2020. I didn't think we could withstand 2016. Because the court would be gone. And if the Supreme Court would be gone, then the lower courts are gone, and then it's all gone. But so we really are playing on the House's money, or we're in the bonus round, whatever you want to call it. But we now have a conservative Supreme Court where we were going to have a liberal Supreme Court. And let me just tell you, however bad the Supreme Court, however disappointed you might be in what the Supreme Court is doing, just imagine what the Supreme Court would have done if that election of 2016 had gone the other way.
Our gun rights would barely exist.
They would be protected solely politically, the way they were protected before 2008, by political action. This is the reason why we had the gun rights we had. It wasn't the courts that gave it to us. It was the gun culture, it was the culture of the American public, and the political pressure that voters could put on legislatures. And I will say this, that from that day, from 2008 until today, so many tens of millions more people are owning guns these days than used to, that the political constituency for gun control is not all that great outside of hardcore blue cities in hardcore blue states.
Yeah, but there is nothing punitively there's nothing in place punitively that the Supreme Court can do to a lower court for define its orders, other than clarifying their decisions.
They can reverse them and slap them down, and lower courts will step into line. They're just like kids now. They're just getting away with what they can get away with. If the parent doesn't step in and sort of establish boundaries, the kids are just going to go crazy. And that's the situation we have right now.
That's right. Throw up another question, Sean. Michael Hens says, can you elaborate on the great crime wave you referred to?
Yeah, in the 1960s, crime in big cities just got way out of control. I mean, it was just amazing. When I would go, that was another problem about civil disobedience and cities getting burned to the ground. But when I used to fly into New York, I felt like I was flying into a third world country. I was coming from Chicago, but New York was so dangerous. That was when I first began to keep my billfold in my front pocket as opposed to my back pocket, so that when I walked through the street, I could actually put my hand in my pocket and know that I wasn't going to get pickpocketed, as I might if it was in my back pocket in New York. It was like flying into a third world country. But then we had The Nixon administration came in 72, had the war, the war on crime. They had established the Law Enforcement Assisted Administration that greatly expanded the criminal courts and gave a lot of money to local police. The Cook County Circuit Court system was greatly expanded, so that you had unbelievably high caseloads in the 1960s. A single judge in Circuit Court of Cook County that was being serviced by 3 prosecutors and 2 public defenders might have 400 cases pending at any given time. And if you have 400 cases pending, you're going to plead out a lot of cases for basically nothing, just to get by. But by the time I reached the felony trial courts, which was, in by the time I got to the felony trial courts, it would have been 1979. There were about 130 by the time I was a felony trial assistant, there were about 130 cases on the call, not 400, not 300 or 400. With 130 cases on the call, we could credibly threaten to try any case that came up, and plea bargaining was much more favorable at that point. So there was a war on crime that was undertaken. Rudy Giuliani was a big part of that in the city of New York, cleaning up New York. We lived for 20 or 30 years with a very low crime rate in this country. And of course, there's nothing that progressives are satisfied with that they can't make worse. And so they decided that how can you put all these people in jail if you have a low crime rate? Wait a second. One reason we have a low crime rate is because
we put all the people in jail.
A lot of people in jail. And so, but no, they've got a better idea. The better idea is we don't put anybody. We don't put anybody in. We get rid of police, and we don't put anybody in jail anymore, and everything is going to be fine. And it's not.
Randy, may I interrupt? And what I'm curious on the Great Crime Wave, and what I took Mike's question to mean as well, possibly I'm wrong, is what caused that Great Crime Wave? What were some of the key factors why did that happen the way it did?
All right. Well, let me just say,
Summer, you don't have to elaborate too much.
I'm hesitant to opine because I have opinions about this, but I don't have opinions as a scholar. So when I go on programs like this, I try to confine myself to things that I consider myself an expert on. Sure. And I have I'm older than you guys, so I lived through these eras, and so I have opinions on what I lived through. Like, for example, I do think most social welfare policies was very harmful to the family. And so there was all kinds of incentives for fathers not to be with their kids, right. And kids need fathers and mothers both. And so the family structure in the 60s was undercut by social welfare policies that had, I think, a lot of effect on criminal conduct down the road, and is still having an effect on criminal conduct. But I say that as a citizen. I say that as somebody who observes what's going on in my life and in the world. I don't say that as a constitutional law expert. I don't like people who have a platform because they're a constitutional law scholar of X, Y, and Z, and therefore every opinion they have on any subject is supposed to be given more credence than the next citizen.
No. Sure. In my opinion, as a citizen, is that's the case in current times as well. With a lot of the issues we're seeing now is due to the family being non-existent.
Yeah, statistically, you can link back one of the number one things to crime, poverty, all of it is broken families. But like you said, that's just one citizen's opinion. One question I do have for you, going back a little bit, what do you think is going to be the outcome of the Brace ruling? I think I would have been able to answer that question better a few weeks ago because I was actually more looking into it than I have been recently. I just don't know. Let's put it this way. If I had an opinion about it, I've now forgotten what my opinion is, so I'm just going to pass on that one.
Was replaced by another opinion.
It's been kicked around by a lot of courts, been lots of different opinions, lots of different, I'm sure you watched The Armed Scholar. He does a new piece on that like every single day. He makes it, his thumbnails will convince you that there's a new ruling on it. It's like you're regurgitating the same thing you said last week.
I get very frustrated by the YouTube bloggers on this subject where they got these great headlines, these clickbait headlines, and you click in. And I've now come to expect that the headline isn't exactly right. And but every once in a while they do have some news, but that's like 1 out of 10 times they have actually some actual news.
Well, that's a great personal question, Randy. With as much as you're publicizing and you're teaching, and maybe this is why, why don't you have a YouTube channel?
It's
all
time.
Spare time, Gary.
It's time. It would
100%.
be another thing I'd have to do. Would be time away from my family and from living the good life here on Siesta Key in Florida. And so,
best answer ever.
Yeah.
I wish I had that answer.
Yep.
I mean, I do. There are other books I want to write. I mean, the next book I have the book in the works talking about my time as a prosecutor called Felony Review: Fighting Crime and Corruption in Cook County. That's going to be a book that I hopefully will publish in about a year. But I want to write another book right now. Today is what I was working on, the introduction to it, which I only have an introduction at this point, on libertarianism and how libertarianism needs to be updated and refined and made more adaptable to the real world than it currently is. And as a lifelong libertarian who was active in the libertarian movement, as I discuss in the Life for Liberty, I feel like I'm in a good position, and I should have some credibility in arguing the limitations of current visions of libertarianism and how libertarianism needs to be made more realistic, and exactly what that means to say that. And so that's what in a division of labor, my highest value, I think, is to produce the kind of scholarship that I'm capable of doing. And I think other people are better YouTubers than I would be. Or at least that's their contribution. They can't write books like I do.
Right.
And even if I could do YouTube like they do, I should be writing the books that I can write.
Yeah.
No, that's fair. No, I think, if you were ever to get out there on your spare time, because, all those reasons that you highlighted is what really prevented me from doing YouTube for a really long time. I hated what was associated with YouTube. I don't know if you feel that way with the legal scholars out there that are on YouTube, or
I like the Four Boxes. I like the Four Boxes Diner. I know him, Mark, and I think he's a smart lawyer. So that's one YouTuber I would listen to.
I'll check that out. But I think there'd be a space.
The Four Boxes is the jury box, the ballot box, the cartridge box. That's what the Four Boxes are about.
Oh, that's awesome. I'll definitely check that out. I think there would definitely be a space. And I think, with your professionalism, with your background, with your experience, I think you would be a welcome voice, even if it was sporadic.
Stop pressuring.
I'm just saying.
There is one other reason. I just thought of the other reason, and that is, when I write, I can be very careful about what I say. I'm a little concerned about what trouble I might get myself into if I were actually called upon to fill airtime. Yeah. Like, for example, tonight. What trouble did I get myself into tonight? I won't find out until tomorrow.
Well, the good news is you will always, no matter how careful you are with your speak, with the way that you speak and what you say, I find that, myself. And that's one of the things that really I wanted to stay away from YouTube. I didn't take it seriously, but and there's definitely people that are much better at YouTube and will always be better at YouTube. But what I know is that the information I put out is valid, it's real, it's proven. And I think there's some value in that.
Well, as I told you, Gary, you first came to my awareness because I saw the review you did of the Smith & Wesson pistol caliber carbine, which I had already bought. I was looking to see, because I like the gun, and I was looking to see what you thought about it. And yours was one of the most thorough, and I watched a lot of videos on it before I bought it. And yours was one of the most thorough takes on that. And I thought, well, look, if he does such good reviews of a gun that I'm familiar with and that I like, then I can trust this guy's opinion on other things. And that was my introduction to Paramount Tactical and your YouTube videos.
Well,
Awesome.
We're going to get you out here to do some training very soon, too. I'm looking forward to I may not be able to meet you in person on that one, but we'll definitely make that happen in the very near future either way. No, I appreciate that. I'm glad I was able to provide you confirmation bias. There's no doubt about it.
I just tweeted. Did you see? Were you watching my Twitter feed today?
No.
Oh, that's what I said. There was
on Twitter at all today.
On X, there was a study that showed that how harmful having cell phones, students having cell phones in schools were. And so I tweeted, yeah, there's I don't need a study to tell me that cell phones should be banned in school. Besides, I'm skeptical of studies. However, I like any study that confirms my biases. So I like this one.
Yeah.
Well, it's an honest one. We got any other questions up there, Sean? Do you think there are more kangaroo courts now more than ever? I guess I'm assuming he's saying politically motivated courts.
Yeah.
We live in a very dangerous and ominous time where we're developing a two-tier system of justice, where the justice goes after some people disproportionately to what they would do to other people, and this is becoming pervasive. I just noticed, for example, you remember if you see in UCLA last week where these Jewish and actually non-Jewish people came from off campus and basically attacked the encampment that was being held at UCLA after an Iranian Jewish girl was beaten unconscious.
Yeah.
And the next day they came and they inflicted some justice on the illegally, no doubt, but they did it. So now today, the news I'm reading, and I tweeted about the two tiers of justice today, is said, well, GESCOM, the DA of LA County or of city of LA, and UCLA have come together and they're going to try to figure out who these people were and they're going to go after them. Oh yeah, well, okay, they're going to go after them. Yeah. So this is part of the two-tier system of justice that we now have. The things that are being done to Donald Trump are definitely would not be done to anybody else. I don't care what they say. Those charges are not, I mean, except for the documents case, but with maybe some qualification there, were completely made up for this purpose as a form of what they call lawfare. And this is just an extremely dangerous environment when the American people can't trust the fairness of the justice system. Now, the justice system I came from Cook County. In my book, I'm going to talk about the corruption that took place in Cook County. Cook County is synonymous with corruption. And so I understand what the real world of courts is like. But even there wasn't the same kind of selective political prosecution that we're now witnessing in this country. And I just can't tell you how disturbing it is for me as a citizen, but also for me as a lawyer. And so I think that's the kangaroo court question is really about that. If I'm interpreting the question correctly, I have to agree.
I think he is. Yeah.
That we have a serious problem in this country, and I don't know how we're going to get out of it. But it's something that we need to be very upset about, very concerned about.
Yeah, no, I think it's actually frightening that you would lay it out there like that, to be honest with you. I feel the exact same way. I felt that way for a long time. We've seen how things went from, and obviously this is on a constitutional side when it came to the impeachments of President Trump that were just ludicrous on their face, at least in my opinion. I think on most people saw it that way, and then to see him prosecuted the way that he has been, very speaking of which, how do you think that the Supreme Court is going to fall on immunity when it comes to President Trump?
Well, I didn't hear the whole. I only heard the last 45 minutes of the argument, and so I turned down press inquiries about my view and I haven't gone back and listened to the beginning of the argument. It sounded to me from the last 45 minutes and from what I read afterwards, and so just this don't put too much stock in what I'm about to say, but it sounded to me like they were going to argue they were going to find that the president could be immune from their and when engaged in official conduct, but not be immune when they're engaged in private conduct. And then they might remand to the lower courts to determine of all the things that President Trump has been charged with, what could be construed as official and what could be construed as private. The government attorney that was arguing to the court maintained that many of the offenses that with which he was charged could be considered private conduct, and therefore would fall outside the immunity box that the court was distinguishing between. But again, I could be wrong. I mean, first of all, oral argument might not be a fair judge of what they're going to do. And I didn't hear all of our oral argument. But if that were to happen, I don't think we should be surprised.
No, I am completely. I did listen to most of the oral arguments, and I couldn't tell one way or the other. I know where I fall on that. I mean, it makes, police, for instance, enjoy a lot of immunity, just in their official duties, and it would be crazy to me the precedent that would set that if we start taking immunity away from the president, especially, and then of course, what is personal actions versus official actions becomes very subjective in that office. But if we get to a point to where we can start going after presidents for criminal prosecution after they get out of office. I mean, I don't know, the hat's in the ring. I don't know what's going to happen there. Like we're done for, because if we're going to do that to Republican presidents, or that should definitely happen.
Stand by.
Yeah, stand by.
Yeah.
This is always the problem, is that, going back to even, judicial activism, like the left is very bold. They will do things that Republicans just never seem to have the backbone to do, and don't have the follow through. But
Use the wrong B word, but yeah.
the one exception to this, which we'll all agree is an exception to this, and that is what Mitch McConnell did with the Justice Scalia seat.
I was going to bring that up. That's like one of the few things that I don't know.
I don't blame the Democrats for being pissed off about that. I mean,
Good.
because for once the Republicans were actually playing a hardball, and if I were them, I would have been pissed off too. Nevertheless,
they were just following the Biden
both
rule.
Senator Leahy and Senator Schumer had previously said about earlier Republican presidents that in an election season they weren't necessarily obliged to consider nominations. So the Democrats had been on record. I did actually have a chance to meet. It's the only time I've ever met Speaker McConnell. Was right after they had done this, and I happened to be at a gathering, and I went up and talked to him about it. And his response to me says, "Well, if the situation were reversed, they'd have done it to us in a heartbeat."
Exactly.
100%.
That's what he said to me, and I think it's true. They would have done it.
Well,
Exactly.
But he did do it, and the 50 Republicans, or however many there were at that time, they hung together, even though that's something else that I would never have expected them to be able to do.
Yeah,
and as a result of that, going back to my earlier anecdote, the Constitution was saved.
Yeah,
it was indeed, by the Biden rule, no less. That was the Biden rule. Yeah. Well, listen, Randy, we really appreciate you coming on. I think it was very enlightening.
Did I run out the clock? I consider the challenge here to be.
My
I
sponge
got
is full, Randy. My sponge is full.
Trust me, we could go another hour or two. There's a whole lot of other.
I'll tell you one little story about this that's in the book.
Sure.
And that is when I was on the Ricky Lake show. Ricky Lake, I don't know if you remember the Ricky Lake show.
Oh yeah,
I do. Yeah.
Yeah. So she in her first year on the show, she actually had serious topics, and the topic I was asked to be on was defendants who were wrongfully convicted of crimes. And so I was asked to be on as a former I was a law professor at Boston University, but I was asked to be on as a former prosecutor to represent that side. And so there was a first session, the first segment of the show. In the studio were all these defendants and their lawyers up on stage, and they brought me in to do the second after the commercial break to do the second one, and I said to the woman who was the tech who was with me, saying, "Well, how long will I be on?" And they said, "Well, that's really up to the producer who's in the booth how long you're on." So I figured, okay, there's the challenge. How long can I stay on this show? It's going to be like a bronking horse ride, right? What is it? What am I thinking? Bucking Bronco. So I successfully stayed on the show for the rest of the show. I mean, 50 minutes I was on that show. And here's the move I made. So when I got on there and she finally turned to me, because I was sitting there, it was me, Lisa Schliewa, who was the wife of Curtis Schliewa, who was then the head of the Guardian Angels, and then all of these defendants and their lawyers. And he said, "Well, what do you as a former prosecutor have to say about defendants who are wrongfully convicted?" I said, "In my experience, when I've seen a case in which defendants were wrongfully convicted, it's usually because of inadequate defense counsel. That is usually their defense counsel were bad and they fell down on the job, because we have an adversary system, and the defense counsel fell down on the job." Now, I thought I was going to get a lot of pushback from the other people on the stage, but all the defendants were starting to nod their head like this, because the lawyers that were sitting next to them were not their trial lawyers. They were their appellate lawyers that got them out, because their trial lawyers had screwed them over by being bad. So that's the last time I had this bucking bronco challenge, and my challenge here was to stay on until 9 o'clock.
Well,
you got 1 minute.
Well, we're actually going to surpass that because I started off this with talking about that we're going to give some books away, and we definitely are. So, with that being said, folks, what we're going to do is we'll do 4 drawings. All right, we're going to give.
Or well, I was going to say we do 2, and the 2 closest get the 2 books. Never mind.
We're going to do 4.
All right.
We're going to do 4.
You know
Out of
how
how
chaotic it
many?
gets.
Out of how many? I'll
Doesn't
pull it
matter.
up.
All right, here's what we're going to do, folks. Pick a. What time is it right now?
8:59.
All right.
About to be 9 though.
About to be 9 o'clock until 9:01. Pick a number between 1 and 100.
One time.
1 and 100. You get one guess. That's it. We're going to be giving away some
Chris,
books.
you guessing? Well, you can't because you have to.
I can't. I'm generating. So
Gary said he's
I'm going to buy you a book.
He said he can buy you a book.
I, know,
I'll make
I got,
sure.
I got the generator.
I'll actually get Randy to send me a special edition with pictures.
Thank
More
you.
pictures.
Here's your first one.
All right. Oh my goodness.
And the book has pictures. It has black and
It
white
does.
pictures. It's going to have color pictures too.
Holy crap,
There's going to
that
be a
dude
color
got it.
picture insert.
That's awesome. I love it when somebody gets it.
You're not supposed to say that.
I can look at how many numbers there are. Somebody got it, so that's awesome.
The number has been picked.
Who will it be? No, everybody else is like, well,
Might as well not even guess. I'll guess on the next one.
The suspense is killing me.
Call the stop. Call the stop. Call the stop.
We got another 10 seconds.
So Sean can put it in.
All right, that's enough. Time stops now.
Sean,
it is.
cut it off after
Oh,
Jason.
it went
Ross.
dead on me.
Let's
Open
just
up.
double
Hey.
click it. Double click it. There you go. Come on.
It's not coming on.
I saw it. I saw the number.
I know, but hey, throw it on this camera right here, Chris's camera, and show him the number. The number is 77, folks. I don't know if this is going to show.
Jared Martinson, if I'm remembering.
Jared
I
Martinson.
think that's who it was.
Jared Martinson sent an email to summer@paramountactical.com
Deuces sevens.
with your handle. We're going to send you his memoir. It is A Life of Liberty.
Life for liberty. I'm
Life
for
for
it.
Liberty.
I'm for
Life
liberty.
For Liberty.
That doesn't come out till July, so
It's going to be July 2nd. Don't be emailing us. Where's my book? Where's my book? All right, it's coming. We're going to get it to you. All right, let's do another one.
For the second copy.
For the second copy of A Life for Liberty.
And we're going to go to 9:02.
902. Whoa.
Guess one time. Between 1 and 100.
1 and 100.
1 in 100.
Go.
Doing fast tonight.
Some people are guessing their same numbers again.
That's fine. I like
That's
John
fine.
Walsh's number. That's my boy.
Put it all on red. Put it all on red.
Right? All on red.
Can't keep up tonight. Not everybody can win.
That's right.
All right, time stops now.
Stop it. Stop it, Sean.
It stopped.
Gonna
You got to write. You got to
put the
write.
text in there.
after
so we know when to stop.
TC at 43.
I was just keeping track of the
Yeah.
names.
All right. Show
All right.
them the number.
Just so y'all know, I like this one. It was a hundo.
Who's
I don't think you can
closest?
see it.
Who's
but
closest to 100?
Whoever's the highest number, I think it's going to be the hundo.
Willie Everett.
Willie Everett.
Send me an email, Willie.
Willie just won something in our last drawing.
He did.
All right.
luck
Perfect.
is-
I just hit the button.
Now we're going with the 14th Amendment book. I'm just
Go.
butchering Randy's numbers.
Bro.
All right. Time starts now. Go.
Original meaning.
The
of
original meaning of the 14th Amendment.
1 to 100. Numbers already picked. Winner's already chosen,
And
depending on how close you get.
I did want to say while you guys are picking your numbers.
And you're going to get a tube of Gary's hair gel.
No, you're not. I don't use
No,
hair
that-
gel. All right. Make sure you guys are, if
That's
you're
the
on
tears of
X,
his
make sure you
enemies.
guys go follow Randy E. Barnett on X. Randy E. Barnett. I haven't caught up with him today, but I've been looking at all his posts as of late. I find them very entertaining
All right,
and
Call a
educational.
stop.
Call
Call a
it,
stop, Gary.
Stop.
Michael Henn.
Mike Henn.
Mike Henn. You got it. It was 2.
I think that's
And last but not least, you
second copy.
you were late, conservative sniper hunter, but I think you're in Australia, so you can only pick one number at a time there.
Mike
Conservative
also won something
sniper
recently.
hunter. He did.
But he earned that one,
And,
though.
and every day he's a winner because he won my friendship.
That's right.
Do I need to pick one more number? Or
Yes, pick one more number. And time starts now.
John keeps guessing the
Get
same.
another
number.
you know what?
30 seconds.
I don't blame John Walsh. Solid number. Randy knows what's
You
up.
even made Randy laugh.
Randy knows
So
what's up.
immature. It's like,
What?
it's
Let
a
me
family
see.
show.
How old
mature.
are you,
I wanna
Chris?
see.
How old are you?
How old?
Me?
He said, "How old?" Are
I
you,
don't look
Chris?
as old as I am.
56?
I don't have any gray in my beard yet, and I will live to that. Now I turned 40 in January, honestly.
40. Oh, you're just a kid.
Yeah.
Right.
All right,
Randy,
time
you're
stops
what?
now.
You're Randy. You're only 10 years older than me. I don't want to hear your shit.
All right. What's the number?
72, my friend. 72.
You doing well?
72
All right.
You doing well, sir?
The
72 is the
number
new 62.
is 44.
I think I saw somebody. with it.
44.
If not, Mike can one again.
Mike,
got
you
a
get 2 copies.
Mike can share it with a friend or
You
something.
know what, Mike? No, he won it, but here's what I'm going to do, Mike. I'll send you his other book as well. So we'll
Yeah,
just
Mike.
switch
Yeah,
them
there
out.
you go.
That's perfect,
Oh, wow.
That's
Yeah.
a good. That's a good.
That's
thing.
how we do. You get the
Yep.
you get the
He's getting
the
2.
library.
Mike gets the Randy Barnett series.
Well, listen, folks. For those of you watching in the future, I will have some additional links down in the description. But Randy's book is already down in the description. I'll put links to some of his other books down there, as well as his Twitter handle. Make sure you go follow him on Twitter. What else, Randy? What
Yeah,
else is
you
out
got-
there?
All right. This is a book called Our Republican Constitution. It explains why we're a republic and not a democracy.
Love it. All right, well, we'll put that. I'm gonna just get a list of all your books, and I'll have you send me anything else, any other social media, any other links that you want, and I'll go ahead.
You
and
got the
share.
Twitter. I only do Twitter. I don't do the other stuff.
Randy, are all your books available on Amazon for people? to
All
buy?
on Amazon.
So there you go. Search his name, and you'll see all the.
It
books
all
there.
comes up. And you also see a lot of content on me on YouTube, and going all the way back till I was young and I had a lot more hair and it was all dark. I mean, there's a lot of YouTube of me if you just do a search on YouTube.
Randy still got hair. So
Yeah, and I will
live
I'm
it up,
lucky.
brother.
I
I'm
will
lucky.
say, Randy, for those of you, Randy sent me the PDF of his book, and there's a lot of great pictures in there that you're definitely going to want to check out. I found very
Oh,
interesting.
sweet. Okay.
So
The color ones are me and my rock band, my 60s rock band that I was in. So
Yeah, that was awesome.
That's going to be the color insert that you didn't get, Gary, but you'll maybe no, you didn't get it. I'll send it to you separate.
Okay,
So,
send that to me.
The
Well,
Royal
listen,
Knight.
Randy, we really appreciate you coming on. Again, it was
Blew
a great
my mind
conversation. I think it was good information that people need to know. And anytime
I want
we
to
have
get out to West Virginia before. I mean, I'm not going to see you in September, but I want to get out there sometime over the summer and get together and do something.
Yeah,
Sounds
absolutely.
great.
Come over. We'll get you in the side by side, ride around, get you a little muddy or something.
we need to get you up for a long range course too. I think you'd really enjoy that.
And also the first aid course that you teach. I think
sir.
that's
That's a solid one.
Yes, sir.
Yeah.
Nobody should be without that one.
right.
Well, listen, Randy, we appreciate it again, and we'll definitely stay in touch. Send me some texts. I'll follow you on Twitter, and we really appreciate it. Folks, make sure you're following us. Make sure you like, subscribe. When this goes away and it becomes a permanent video and not live, all the comments will go away. So if you can go back, like, and throw some comments up there, that helps us. Share this. Make sure you're here every Wednesday at 7 p.m. But until next time, stay armed, stay ready, and we'll talk to you soon.